Oberlin. Do I do the article? Let's do the article first, so that we're just going to summarize this real quick, and then I'm going to go through some paragraphs. I took notes. Put these over here. Actually, the only reason I want to highlight this: Oberlin College loses appeal against $25 million libel judgment from suit filed by local bakery. Don't care about anything in Hollywood. Get away from me. I like Denzel Washington's quotes. I don't like anything else. Okay, they've upheld the $25 million judgment for business that successfully claimed it was libeled by Oberlin College in the aftermath of a shoplifting incident that roiled the historic liberal arts school and music conservatory campus outside Cleveland. What? Talk about whitewashing the egregiousness of what? Forget that. The only thing I want to go to, we'll get to it. Oh, yada, yada, yada. Yada, yada, yada. The bisque was okay. The three-judge panel also agreed with Lorain County Judge John Moraldi's decision, rejecting Oberlin's college motion for a new trial and they denied the store owner's claim that the damages awarded did not sufficiently punish the school. We'll get to that. The only thing that I wanted to highlight in all of this right here, people say, they scored a payday. 2 of the members of the Gibson family died because this took so long. Someone dies at 93. That was Alan Gibson. I think blessed is he or she who lives to 93. David Gibson died in 2019 at 65. My father-in-law passed away from cancer at 62. And that's too young. 65 is too young. We should be thankful for every day on earth. But that doesn't, I'm not going to lie, that doesn't mean not being resentful for lives cut way too short. And cut way too short, I would just argue that having lived through what Oberlin did to Gibson Bakery, a family-owned business that was bankrupted as a result of what Oberlin did, said, incited others to do, that will put people in an early grave. Without question. Nobody understands. Everyone thinks litigation is fun. Litigation, what did I just do? I hope I just close down the stream. Litigation is not fun. It's endless stress. But setting aside the litigation part, having your lives, your livelihoods, your reputations, your very integrity, the only thing that you leave behind, sorry, I screwed up my own expression. The only thing that you take with you in this life is what you leave behind. That is your integrity. That is your reputation. And what they did to the Gibson's Bakery, well, let's just see what they did to Gibson's Bakery. Stage 4 at 56, time to fight. And it's first of all, I love that dog in the back. It's the thing of life is that, your life is filled with all sorts of projects, life projects, and then you get news where your new life project becomes a literal existential fight against something that blindsides you. And it becomes now your purpose in life is to fight this. So Godspeed and God bless, Mike. Does everyone know Pee Wee? There was an amazing channel that I was following for the longest time. Pee Wee Tom. Pee Wee Tom. Pee Wee Tom. Yep. Well, I'll just do this. If anybody doesn't know, Pee Wee Tom's was a young man diagnosed with cancer, and and he documented his life and ultimately his death from cancer. Mm-hmm. White pill for Viva. Believe in the triumph of the human spirit. Tyranny cannot win as long as information continues to awaken the people. That's the problem. And what do you have to do to control the free flow of information? Demonize everyone and anyone who disseminates it. So Pee Wee Tom had a channel documenting it. It's tragic. I don't even know why I thought about that. But yes, but that was it. So your other plans of life put on hiatus, and the plan of life for those who are afflicted with any tragedy, it's becomes to fight that, survive that, thrive beyond that. So to say that the stress of litigation is one thing, to the stress of having your life ruined, your reputation ruined, because you can't overestimate the toll that takes on one's health. So let's go here. Let's just go. Gibson's Bakery. This is the judgment. Let me see if we can see this properly. Just going to highlight. It serves for a reminder. I can't see I can see the super chats while I do this, actually. Paragraph 8 and 9. So, okay, both parties were appealing the decision. The decision, for those of you who don't recall, jury condemnation, unanimous, guilt. There were monetary damages of, I want to say $11 million and punitive damages of $33 million because there was some cap at 3 times the monetary damages for punitive damages. It was reduced from 44 million to 25 million. Yes, that's a lot of money, but you ask any of these people, I'm sure Gibson's Bakery, we just wanted to have the life we had before. $25 million is nice. And to go back to my recurring quote from Good Will Hunting, oh geez, I always forget her name. It has an M in it. Minnie Driver, talking about her, getting an insurance payout from her father's early death, trade it all for another day with him. Okay, the controversy in this case, this is where we are, paragraph 8, people, arose following an incident at the bakery. Remember how USA Today summarily described that? The controversy in this case arose following an incident. What's my problem here? An incident at the bakery on November 9th. Although media coverage may have included other details about the incident, this court is confined to reviewing the record before an appeal. Standard rules, there's no new evidence on an appeal, typically, unless you make a motion to adduce new evidence for compelling and extraordinary reasons. According to testimony admitted at the hearing, 3 African-American Oberlin students, 1 male and 2 female, were in the bakery while young Allen, I think that's the younger one, not the deceased young one, was working. Young Allen later informed the police that he confronted, if that is the Allen that passed away at 65, someone in the chat let me know. Young Allen later informed the police that he confronted the male student because he believed that the student was shoplifting wine and using a fake ID to purchase more alcohol. That male student fled the store, and young Allen chased him across the street to apprehend and detain him for the police to arrive. When a police officer responded to the scene, he observed that 2 female students also became involved in the physical altercation between young Allen and the male student. 1 screen, 2 films. Some people see this as young Allen physically assaulting a young African-American student who did nothing wrong. Others see this as 3-on-1, the people who were shoplifting and allegedly using a fake ID to procure alcohol then proceeded to assault young Allen. The police arrested the 3 students. The students eventually entered guilty pleas and were convicted for their roles in the incident. Then listen to this. And you want to talk about what Oberlin did, the most liberal of liberal schools. And I say liberal doesn't necessarily mean being dishonest, malicious liars, but for Oberlin, apparently that's what it means. Several college administrators testified that rumors about this incident at the bakery quickly reached members of the student body because many Oberlin students apparently believed that the 3 students had been racially profiled by young Allen. They announced they planned to hold a protest outside the bakery at 11 the following day, and the record does not disclose details about who prepared the flyer. A 1-page flyer was prepared to be distributed during the protest. The flyer urged a boycott of the bakery. Had been there for I think 100 years, if not over 100 years. I think if it's not 100 years, it's a long time without incident. But this is the flyer urged a boycott of the bakery, asserting that it was a racist establishment with a long account of racial profiling and discrimination. Emphasis in original. The flyer also gave account of the heinous event involving the owners of the establishment and stated that Allen Gibson had racially profiled the male student, improperly chased him out of the store, and assaulted him. Paragraph 29 is the next one that I had of interest. Oh, this is the this is what was in the flyer. And so, it's not just that Oberlin tolerated this. The student Senate passed a resolution, which we have in paragraph 30. The Senate resolution was passed by the Student Senate on November 10, 2016. It urged students to cease all support of the bakery and called upon the faculty and administration of the college to condemn the treatment of students of color by Gibson's Food Market and Bakery. Rather than quoting the resolution in its entirety, the court will summarize. Okay. The Senate passes this resolution, which the university, by all accounts, knew was publicly viewable and did nothing to remove it, to correct it, or to quell the animosity, which, by all accounts, was based on misinformation, to put it politely. 57 is what I had here as relevant. This is much different, a much different pace than the car vlog. So you got the Student Senate passing this resolution. You have flyers being handed out, which it's not clear who put them. But Oberlin's role in all of this was not merely that of a passive observer. Shortly after the Gibsons filed the lawsuit, Raimondo, who was the dean, I believe at the time, asked members of the Student Senate to remove the resolution from this. That's over a year, I believe, which they did. A reasonable juror could also infer from the evidence that Raimondo, as the faculty advisor, had the authority and or obligation to instruct the Student Senate to remove the resolution many months earlier. Therefore, they're basically just saying, like, we've seen all the evidence. We don't determine that there was any mistake in all of this. And you know, Oberlin said that it was called a judgment notwithstanding verdict. They said that, fine, the jury came to a unanimous verdict, but the judge should dismiss that, toss it, set it aside for a number of reasons, because this should have been dismissed on its face because Oberlin didn't do anything defamatory. Oberlin didn't interfere with business relationship. And the appeals court said, no. You know, let me take a pause there for 1 second and just see what we've got going on in the chat. Okay, we've got something on C11. All real speech is hate speech. All acceptable speech is pleasantries or rhetoric. Keep speaking. This is the thing. I would say hate speech. There are already laws against hate speech in the actual sense of hate speech. There's laws against threat. There's laws against targeted harassment. There's laws against defamation. So, you know, Tacitus is what it was. More laws, less justice. We got that. So you know, Oberlin tried to appeal it. They say, oh, the judge should have dismissed this, notwithstanding the conviction. The judge should have dismissed this on a motion to dismiss because there was no defamation. To which the Court of Appeal, rightly, in my book, said, no freaking way, but in judicial terms. 63, what did 63 say? Oh, interference with business relationships. Wait, it's not just that Oberlin actively participated in the demonizing, the libel of this bakery. You know, they then went and said to other third parties, stop doing business with Gibson's Bakery. After the jury trial, judgment was granted on behalf of Oberlin, but against Raimondo and the Gibsons' claims for intentional interference with business relationship. Oberlin argued in its motion for judgment notwithstanding verdict that based on the evidence presented at trial, Raimondo also should have been granted judgment on this claim. The torts of interference with business relationships and contracts rightly generally occur when a person without privilege to do so induces or otherwise purposely causes a third person not to enter into or continue a business relationship with another. Now, let me just see where they describe what they did, because it's just atrocious. Here we go. Listen to this, people. Listen. I really suck at highlighting today. Forget it. We're not doing it live. The Gibsons presented several printed text and email messages between senior college administrators to demonstrate that nearly a year after the bakery incident, they did not believe that the college should work with the Gibsons to resolve the situation. Oberlin's witnesses did not dispute that the printed messages had been communicated between the administrators. One text message sent by the interim assistant dean expressed that the criminal conviction of the three students was an egregious process, and that she hoped the college would, quote, rain fire and brimstone on the bakery. Can you imagine this? This is, they get robbed, or they get shoplifted from. The individuals plead guilty. They probably got a slap on the wrist regardless. This is not shoplifting is not a victimless crime, but there are worse crimes. They get victimized by the shoplifting, and then they get victimized for availing themselves of their rights to the point where Oberlin administrators in private text rain fire and brimstone on the bakery. In response to a published letter from a retired Oberlin professor who criticized Oberlin's response to the college's situation with the Gibsons, Raimondo stated in another text message, F him. I'd say unleash the students if I wasn't convinced this needs to be put behind us. The Gibsons presented other messages that were communicated between senior administrators that also expressed their lack of concern about the past and ongoing damages suffered by the Gibsons. Can you believe that? And they appealed this decision. I mean, God, oh, hold on, wait until we get to the damages part because it's a lot of money. Construing this evidence in favor of the Gibsons, this court cannot conclude that reasonable minds could only conclude that this conduct failed to rise to the level of extreme and outrageous. Therefore, this is a backwards sentence. It was extreme and outrageous. A reasonable person could have concluded that. Therefore, the trial did not err in denying the J-Onivy on this basis. Then we get into the punitive damages. Finally, Oberlin argues that the trial court erred in denying its motion for judgment, notwithstanding verdict, in that it should not have been allowed to consider an award of punitive damages in the bifurcation. It's complicated. It's sort of, do we want to get into it? Oberlin alleges that because the jury had already found no actual malice in the liability stage of the trial, it was improper to further consider punitive damages on the libel claim. So here, and it's an interesting thing, we don't really need to get into it, but no malice. First of all, if that's not malice, what we just read before, I don't know what is. But what the judge basically came to the conclusion is this was calling someone racist and saying they have a long history of racism is defamation per se. And the court concluded that under the law here, when it's defamation per se, there's a presumption of malice and you don't need to actually prove it. So no go. End of discussion. But let's just get the part which we don't need to read this. This is too technical. And then 88. What was on 88? Oh, well, this is the legal part. Because Oberlin did not request bifurcation, however, after compensatory damages were awarded by the jury, the Gibsons were entitled to proceed to the second stage of trial and put on every evidence they had pertaining to punitive damages for each of their claims: defamation, intentional infliction of emotional distress, and tortious interference with business relationships. Because Oberlin specifically said it to a third party, don't do business with them anymore, and that third party stopped doing business with Oberlin. All right, and then I think we can skip the rest. It's just the facts of this case and the egregious conduct of Oberlin and its employees. It's up to you whether or not you want to forgive it, but it should never be forgotten. Compensatory damages. Oberlin argued that even applying the damages cap, the award is still exorbitant. It argues that there was no witness testimony as to any losses caused by the flyer or resolution. It also argued that any economic loss caused by the alleged hostile environment created by the protest was merely speculative. They went out of business. They had been in business for decades, including the belief that the harm would continue for 30 years. The Gibsons argued that they presented sufficient evidence and of their damages, as well as the fact that it flowed from Oberlin's tortious conduct. And they agreed. But 124, where was it? They talk about the percentage of Oberlin's net assets that this related to. Hold on here. Here we go. The Gibsons note that the jury initially awarded them $11 million in compensatory damages and $33 million in punitive. They assert that the jury's punitive damages award represents less than 3% of Oberlin's total assets. Noting that the purpose of punitive damages is to appropriately punish and deter defendants, the Gibsons argue that a purely okay, whatever they say. It only represents 3% of their total assets, so it should make it more so that it's really effective. And the judge said, "Nah, no, not the law, and it doesn't matter." But can you appreciate, by the way, 3% of Oberlin's total assets? That means that that's a substantial portion. 3%. I mean, when Facebook and the other tech giants, Gibson's Bakery is still in business. Hold on one second. I'm going to go fact check myself in real time. Hold on, people. Gibson's Bakery. I'm looking up bankrupt because I thought they closed. 11 million. Hold on. Gibson's Bakery closes. When did they close down during this? Hold on. I will verify that. If it is still in business, there was the issue, but there was the issue of the damages, and they were determining how much that business was worth at the time. Okay, hold on one second. I will correct myself if that is the case, because I don't like being wrong. Give me 30 seconds. Oh, they seem to be open, so that's good. Okay, so I'm gonna double check what it is exactly that they closed down, for how long they closed down, because I do believe they closed down at one point. That was part of the damages. Let me see if anybody in the chat who knows better knows. Okay, they may have closed temporarily, but I'm not sure about that. Okay, I'm certain they did, because they had no business and they lost their contract. And the issue about damages during the trial was that how do you assess the value of a business that had been around for a century? Okay, well, it was important fact, but not determinant to the outcome, which is $25 million damage against Oberlin, which means the donors, the philanthropists, what are they called? The people who support the institution are now paying off the consequences of the most egregious, hateful, malicious, spiteful conduct imaginable. I don't want to use the standard expression. There should be consequences for this. Everyone involved in this should probably trustees. Everyone involved in this people should vote with their dollar. I do know people who announced that they would not support Oberlin through donations because of this, but they're gonna live with the consequences of what they did, because it was egregious, and I don't know if it's unforgivable, but it's unforgettable. Okay, let's just see. I just want to see if anybody knows. Gibson's whiskey is not bad. It's let's just see here. 30 seconds expired. Okay, no, that's the Gibsons. I don't think it goes anywhere else from. I mean, I don't know that it goes anywhere else from here. Technically, there's always an appeal to the Supreme Court. Not sure what novel questions of law there are here. And bottom line, affirming the jury's findings, there have to be some very egregious mistakes or very important questions of law. So I don't know. I think it's over here. And congratulations, Oberlin. Everything woke. If it doesn't go broke, it certainly gets 3% of your assets to pay the damages of your actions. All right.